Welcome to the Supreme Court landmark case presentation. In Fallout 76, this will go over to major Supreme Court cases. United States v. Lopez and Lopez Bright Enterprises v. Raimondo, both representing the enforcement of the balance of powers. Again, welcome in. And let the experience begin.
Hello, class. Here we have two SCOTUS cases, both working around the concept of Congress being balanced in power. The first case is United States v. Lopez.
Order! We come together today with Lopez versus the United States on April 26, 1995. The petitioner, Alfonso Lopez, and the respondent is the United States. The question brought forth today is whether bringing a firearm into a gun-free school zone is a federal crime under the Commerce Clause. For a refresher, in case anybody here forgot, the Commerce Clause grants Congress the power to regulate commerce with foreign nations and within states.
Before this case begins, it is important to note that the Commerce Clause grants Congress the power to regulate commerce with foreign nations and within states.
Present your cases. Alfonso Lopez, start us off.
I am a 12th grade student who brought a firearm within a school zone and was subsequently charged with violating the Gun-Free School Zones Act. This was counted as a federal offense, but I chose to challenge it by arguing how the act exceeds the Congress's power under the Commerce Clause.
Now, the U.S. will present its case.
We argue that guns in school can lead to violence and danger, affecting insurance costs, discouraging transportation in the area, disrupting the learning environment within the school zone, and other effects, which could lead to less educated citizens, which could harm commerce. Alfonso Lopez is in clear violation of the Gun-Free School Zones Act, making his wrongdoing a federal offense. He violated a federal law.
While the federal law was broken, is the Gun-Free School Zones Act a federal law and not just an overreach of Congress's power to control interstate commerce as directed in the Commerce Clause? Bringing a firearm in a school zone does not pertain to any commercial activity and has very little, if any, effect on interstate commerce.
That is very true to deem that if the Gun-Free School Zones Act has little to no correlation with interstate commerce, the necessity of Congress involvement is, in fact, an unconstitutional overreach of power. Under the Commerce Clause, this violation does not fit the criteria. On Alfonso Lopez's violation of the Gun-Free School Zones Act under the Commerce Clause, we find in favor of Alfonso Lopez's being accused of an unconstitutional act that is beyond Congress's powers, terminating the federal crime. Now let's go into the majority, concurring, and dissenting opinions.
Majority opinion identifies the three broad categories of activity that can be regulated by Congress under the Commerce Clause: use of channels of interstate commerce, instrumentalities of interstate commerce, or persons or things related to interstate commerce. The court concluded that the Gun-Free School Zones Act did not fall in either three categories.
Concurring opinion agreed that the Gun-Free School Zones Act exceeded Congress's power under the Commerce Clause. Also, concerns existed about the broadness of the Commerce Clause, enabling Congress to regulate almost anything if the law is upheld. The justices acknowledged the importance of education and the dangers of guns in school.
But dissenting opinion argued that the gun's presence does interfere with interstate commerce, since education is necessary for economic productivity.
From U.S. v. Lopez, key facts.
Order. We come together today with Lopez Bright Enterprises versus Raimondo on June 28, 2024. The petitioner, a family-owned New Jersey herring fishing company, Lopez Bright Enterprises, and the respondent, the Secretary of Commerce, Gina Raimondo. The question brought forth today is if the National Marine Fisheries Service, NMFS, is allowed to require fishermen to pay for the federal monitors that regulate their vessels under the Magnuson-Stevens Act.
To prevent y'all from getting lost, here are the need-to-knows before we start this.
Lopez Bright Enterprises, start this off with your case.
We are here to contest the National Marine Fisheries Service rule that forces us to pay $700 daily to fund the federal monitors who board the vessel and check supply and regulations. The Magnuson-Stevens Act does not grant the NMFS the ability to impose those costs onto us.
Mondo, You may now place your argument.
NMFS does, in fact, have the authority to require fishermen to pay for the federal observers under the Magnuson-Stevens Act, according to the Chevron Doctrine. This agency is an expert in this field, meaning that they know what to do without relying on the court, and instead utilize the agency's interpretation.
The long-lived Chevron Doctrine. The decision has been made that giving Congress the ability to interpret laws to the Supreme Court, instead of just giving in to the knowledge of executive agencies, is the more constitutional option. The Chevron Doctrine will be overruled, now enabling Congress interpretation instead of the agencies. The majority opinion states that the Administrative Procedure Act requires courts to have their own judgment on the topic of an agency's authority. The court may not defer to an agency's legal interpretation solely due to multiple perspectives. Chevron was proved to be fundamentally misguided and dysfunctional, including too many steps and actions that are full of exceptions and limits. The concept of agencies having special expertise to assist cases was also shut down. Justice Thomas.
That was the Loper Bright Enterprises v. Raimondo 2024 case. Any questions?
How do the Scottish cases connect?
Teacher, both of these cases relate to the separation of powers and the balance of Congress powers. United States v. Lopez restricted the power of Congress with the Commerce Clause's reinterpretation, giving more power to the designated executive agencies. In Lopez's case, the Gun-Free School Zones Act is enforced by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, which is an agency. In Loper Bright Enterprises' case, the power once held by agencies through the Chevron Doctrine was overturned, now lessening their power and influence on court cases while boosting the power of Congress, allowing Congress to interpret for the judicial branch, not the agencies doing the interpreting. Essentially, Lopez lessened Congress power and Loper Bright Enterprises enhanced Congress power while lessening the agency's power. That concludes the lesson.